Hello all and welcome to our first webinar of 2021. This is the second in our monthly series, providing with more information on the residential property market, including areas which you should be aware of as a property investor. I'm just looking at the number of participants. We're slowly getting those numbers up. So before we start, just to mention again that these webinars form part of our risk reduction strategy to our owners. And please feel free to email us your suggestions for future topics. So thank you for joining us today. We have upgraded our sound system following issues raised at our last webinar. And as always, we always welcome feedback as a measure to improve our service to you. The webinar will be recorded and attendees will be sent a link to the recorded video. Just check those participants. Yep, the numbers are still going up there. So just waiting for everybody to join us. But yep, today we are tackling the amendments to the Residential Tenancies Act, which as you can imagine is quite detailed. And the purpose of our webinar today is to introduce you to the majority of these changes, most of which will become effective tomorrow, as well as give you some insight as to how these changes may affect you as a landlord. So I'm sure there are going to be many questions as we go through the slides. And I would ask that you send through your questions as we go along, and we'll look through these at the end of the presentation. I'm joined today by my colleague, Jessie Wu, who will pop in at the end of the session to assist with answering your questions. And if we don't manage to get through all the questions, don't panic, we are recording, and we'll contact you directly to discuss these. And of course, both Jessie and myself are here for you to contact at any time. As you can see on the screen at the moment, our mobile numbers or our email addresses. Happy to answer any questions or concerns that you may have. And of course, if it is a property specific inquiry, feel free to contact your property manager. So just checking those numbers again. Yep, we're good to go. So before we start, I'm just going to quickly pop into our Q&A. Make sure that everybody can hear me and that there's no technical difficulties. I have no questions, so I'm assuming we're good to go. Right, let's have a look at those numbers again. Yeah, we're good. All right. So I guess let's get started. We've got quite a bit to get through, so we'll just hop through to our first slide there. So the Residential Tenancies Act. The reforms to the Act became law on the 11th of August last year with the passage of the Residential Tenancies Amendment Bill. And the reforms modernise New Zealand's rental laws, and they align them with the present-day realities of renting in New Zealand. The commencement dates for these law changes, will have a three-phase rollout. First phase, of course, already in effect, took place on the 12th of August last year, and that was when the law regarding rent increase limitations took effect. The second phase, coming into law tomorrow, is where most of the remaining reforms take effect and the majority of what we'll be going through today. And of course, phase 3, which will be the 11th of August next year, 11th of August this year, and that's the family violence and physical assault of landlord reforms. So let's get straight into it. So phase 1, this is already in effect, rent increases. Rent increases can only happen now every 12 months. So from the 12th of August last year, rent increases are now limited to once every 12 months. And this is a change from the previous law where we could effect this every 180 days or 6 months. Any rent increase notices that are given to tenants from the 12th of August last year, 2020, must comply with the new 12-month rule. And if a notice was given before the 12th of August 2020, it's still within the 180-day rule. So potentially you may still have time to sneak an increase. So practically, the only instance where your rent may now be increased within a 12-month period is if you start a new tenancy. While there are no stated penalty fees for an infringement of this section, a tenant may make an application to the Tenancy Tribunal to render the rent increase invalid. I also wanted to add a quick note here about bond collections at the start of a tenancy. The bond amount may not exceed 4 weeks and must be paid to the bond centre within 23 working days of receiving it. And if the bond is not lodged within this time, bond centre may note that the tenancy, sorry, let me start that again. If the bond is not lodged within this time, when the bond is lodged, the tenancy centre can note the date, start date of the tenancy in relation to the late bond payment, and you may be liable for a fine of $500+. So really important. So let's just quickly move on to the beginning of phase 2. So the first item under this section, again, phase 2 effective from tomorrow. And the first section here is the security of your rental term. This tracks the highest fine of up to $6,500. And under this law, landlords will not be able to end a periodic tenancy without cause. And new termination grounds will be made available to landlords under a periodic tenancy, and the required notice periods will change. So looking at those required notice periods, we have a 63 versus a 90-day notice period. So when may we use each one? So on 63 days notice, the landlord may give this if the owner or a member of the owner's family requires the property as a principal place of residence. And secondly, if the landlord's employees or contractors require occupation of the property. Secondly, on the 90 days, the landlord may issue a 90-day notice, A, if the property is to be sold, if extensive renovations are to take place, and a project plan, just a note here, will need to be provided, or if the premises are to be converted to commercial use or to be demolished. Right, so hopefully I'm not going through this too quickly for you. Right, I'll pop on to the next one. Next one, also quite a controversial one, fixed term tenancies. So again, effective tomorrow, and essentially what you need to know is that all fixed term tenancy agreements will convert to periodic tenancies at the end of the fixed term, unless the parties agree otherwise. The tenant gives a 28-day notice, or the landlord gives notice in accordance with the termination grounds for periodic tenancies. So what this means is, if you want to terminate for non-payment of rent, assault or antisocial behavior, or damages on a fixed term, the tenant must receive 3 written notices over a 90-day period before an application can be made to the Tenancy Tribunal for termination. Next one, making minor changes. So tenants may ask to make changes to the property, and landlords may not decline if the change is minor. Just popping back up to the first line there, this can attract up to a $1,500 fine. Landlords must respond to a tenant's request to make a change within 21 days, and tenants may not make changes without prior consent and must reinstate where possible at the end of the tenancy. So, practical application. The Act defines a minor change as any fixture, renovation, alteration, or addition to the rental property that is low risk and won't cause material damage, is easily returned to the same condition, doesn't pose a health and safety risk, doesn't compromise the structural integrity, whether tightness or character of the premises, won't negatively affect the neighbours, and doesn't require building or resource consent. So it is the tenant's responsibility to return the property back to its original state at the end of the tenancy, and such minor changes may include installing a pet door or hanging a TV on the wall. Let's just note here that painting walls are noted as a minor change. However, the request may be denied by the landlord if the colour is dark. For example, a tenant wants to paint the room black or red. This could be viewed at the end of the tenancy as intentional damage. Also to note here, all chattels have a useful life, and this should be taken into consideration when you're assessing your damage claims. For example, wallpaper has a useful life of 7 years, carpets 8 years, and windows infinity. So when you're assessing your changes and the potential damage, it's worth asking the question, will the damage done prevent the property from being rented or achieving market rent? And if no potential loss is foreseen, then no claim should be made. Just trying to keep it as simple as possible. So, right, popping on to the next one. Prohibitions on rental bidding. Rental properties cannot be advertised without a rental price listed, and landlords cannot invite or encourage tenants to bid on the rental or pay more than the advertised rent amount. So, practical application. One can no longer put up a for rent sign outside the property. This now must, I should say, one can no longer simply just put up a for rent sign outside the property, and this sign now needs to actually reflect the rent amount per week. And secondly, tenants may still offer a higher rent per week to gain a rental property, but this in no way is to be encouraged by a landlord and must absolutely come from them. So we'll pop on to the next one, which is fibre broadband. So tenants can request to install fibre broadband, and landlords must agree if it can be installed at no cost to them, unless specific exemptions apply. And this can attract up to a $1,500 fine. If the structural integrity of the property is compromised, then installation of fibre may be denied. However, we would suggest that if there is a charge for installation of fibre, that the landlord considers this, as it would be for the greater good of the property. And then just a note here, our fantastic body corporate team have been very hard at work to ensure that most of our managed buildings have fibre installed. Of course, this again makes it more attractive to tenants, which is what we aim to do. So popping again to the next one, privacy, name suppression. So a suppression order can remove names and identifying details from a published tenancy tribunal decision if a party who has applied for a suppression order is wholly or substantially successful, or if this is in the interests of the parties and the public interest. Basically, this means that if a tenant has won a tribunal case, their name will no longer come up when a credit or a background check has been completed on them. And that's a discussion for another day. So move on to the next one. Right, assignment of tenancies. All requests to assign a tenancy must be considered. Landlords cannot decline unreasonably, and if a residential tenancy agreement prohibits assignment, it is of no effect. So the practical application here. An assignment of tenancy is the transfer of tenancy between the current tenant and the replacement tenant. It is not swapping tenants because they are jointly and severally bound in contract, and it is an assignment of rent and tenancy obligations to the replacement tenant. The landlord is expected to give consent. However, the replacement tenant must be as good as the current tenant, and the landlord is well within their rights to request the completion of a tenancy application form and not give consent until credit, background, and other checks have been completed on the new tenant. If the tenant assigns tenancy without the landlord's consent, they can face up to a $750 fine. Landlords may only claim costs for the reassignment of tenancy at the end of the process, and this must be a detailed statement indicating individual costs incurred, for example, administrative, credit checks, etc. Moving along to landlord records. Not providing a tenancy agreement in writing will be an unlawful act, and landlords will need to retain and provide new types of information. This can attract up to a $750 fine. Professional property managers will have specific systems in place to ensure landlord compliance. Practically, a tenancy agreement remains enforceable even if it's not in writing. However, landlords will now be fined if it's not in writing and co-signed between both parties. Some examples of the type of information required in keeping records. We're looking at tenancy agreement, variations, extensions, and assignments, inspection reports and or photos, videos, maintenance, specifically electrical work, gas fitting, sanitary plumbing, healthy homes compliance and relevant certifications, advertisements for the tenancy, notices and correspondence between the landlord and tenant, and rent and bond records. And of course, the professional property manager will ensure that all of this information is kept. So we're almost at the end, unbelievably. So enforcement and jurisdiction. Enforcement measures of tribunal outcomes have been strengthened. The regulator, who is the Ministry of Business, Innovation and Employment, will have new measures to take action against parties not meeting their obligations. For example, large landlords. Changes to the tenancy tribunal jurisdiction. The tenancy tribunal can hear cases and make awards up to $100,000, and this is now a change from $50,000. So practically, the Act defines a large landlord as one that has either 6 or more rental properties or a boarding house. It is worth it to note here that people connected via marriage, partnership, whether it be domestic or business, and company directors are considered a single unit, with each individual in that unit seen as a large landlord. So for example, we have a husband and wife and they each have 3 rentals. They are both considered a large landlord, in this instance, meaning more responsibility towards compliance and potentially higher infringement notices. So that's the end of phase 2, which takes effect tomorrow. We have now to go through phase 3, which will take effect in August this year. Essentially, tenancies can be terminated if family violence or landlord assault has occurred. Family violence, tenants experiencing family violence will be able to terminate a tenancy without financial penalty. Physical assault, a landlord will be able to issue a 14-day notice to terminate the tenancy if the tenant has assaulted the landlord, the owner, a member of their family, or the landlord's agent, and the police have laid a charge against the tenant in respect of the assault. Let's get into this. So please note here that the 14-day notice to terminate must include 3 requirements. The tenant has physically assaulted the landlord, property manager, or neighbor. Secondly, a file has been charged by the police and a case number has been provided. And thirdly, the charge must refer to assault. Family violence, the tenant may give 2 days notice to vacate if qualifying evidence is provided. And the remaining tenants that remain liable for the tenancy and may receive a temporary rent reduction for 2 weeks to the value of the exiting tenant's contribution. So for example, we've got 4 tenants paying $100 a week. Tenant number 3 exits, then the remaining 3 tenants only have to pay $75 for the 2 weeks until they find a replacement, I guess. So unfortunately, in both instances, the physical evidence has to be provided before such terminations can take place.
So might come back for next one.
I think so.
Yeah, and if you have any questions, like feel free to contact the Toni or me by email or just give us a call.
Yeah, have a look on screen. Again, our contact details are there. Thank you very much for attending today. And as I mentioned, do send through some suggestions if you'd like us to talk about any topics that have you concerned. So yeah, good talking to you, and we'll talk again soon. Bye-bye for now.